welcome to our first part of a two-part webinar that One Valley is hosting in conjunction with our partners at Oracle for Startups. Today, we're very lucky to have Matt Savare of Lowenstein Sandler, who will be conducting an interactive webinar with us today around IP strategies such as copyright, patents, and trademarks. Before we get completely started, I want to just remind everyone about Passport and what we offer. Passport is the world's most comprehensive digital innovation platform. We connect entrepreneurs and emerging startups to access to vital resources, networks, and significant savings on essential business tools. We have over 25,000 global members, over 140 mentors, 450 investors in our private VC Connect program, and over $1 million in discounts and services that startups need to get to their next level of growth. Today, we're going to be doing something a bit different than normal. We will be hosting a raffle at the end of this event. So anyone who RSVP'd will be entered to win one free year Passport. This is a $600 value. And we'll announce the winner in the follow-up email that will go out either tomorrow or Thursday. So make sure to keep an eye out for that. Lastly, before we get started, Matt has kindly said that we will be answering as many questions as we can today. So please put any of the questions you have in the chat. He will try to address all of them as we get through the event. And then finally, I'm going to hand it over to Rohit from Oracle, who's going to give us an overview of Oracle for Startups.
Thank you, Kara. I'm just going to share my screen. It'll just be a moment. Kara, can you see my screen?
Yep, it looks great. You can just go into presentation mode.
Okay, great.
Perfect.
Well, thank you, Kara. Hi, everyone. Good morning, good afternoon, good evening. I'm fired up to hear Matt Savare from Lowenstein Sandler discuss identifying IP strategies, including copyright, patents, and trademarks as it relates to startups. Oracle for Startups puts on many different workshops to support the startup community, and I'm excited for this workshop series with One Valley and Lowenstein Sandler. And my name is Rohit Jain, and I am the North America Business Development Lead, Oracle for Startups, based in San Francisco, California. And would love to give you an overview of our Oracle for Startups program. Oracle for Startups works with thousands of startups across the globe. Today's startups are born in the cloud, and that means that their choice of a cloud provider is of the utmost importance. What do startups look for when evaluating cloud providers? Value, performance, and security are some of the most crucial factors. And they're just a few of the reasons startups choose Oracle Cloud. Earlier this month, I spoke to a startup that saw their cloud bill continue to rise and receive minimal support from one of our cloud competitors. In today's startup environment, every dollar of savings matters. And we saved the startup over 70% off their cloud bill. The cloud savings allowed the startup to now hire additional staff. And our startup technical team provided amazing support and made it easy for the startup to migrate to Oracle Cloud. And some more information on Oracle Cloud. If you're rolling right out of the door, there's a place. If you're a Series A or B company, there's a place. Startups are the ones pushing people to do things, and our enterprise customers want to tap into that. And let me just make sure. Okay, great. They want to tap into that. Oracle has 430,000 plus enterprise customers. For startups to get access to both them and that knowledge is like getting a golden ticket. Essentially, we are creating a virtuous cycle of innovation by facilitating connections between Oracle business units, startups from our program, and our enterprise customers. This way, startups from our program and enterprise customers can all win and have more agility and efficiency. And to highlight some of our startup program, we don't take equity, don't charge any fees. It's open to any startups and innovators worldwide. and there's, as I said, there's no application process, year-round enrollment, and you just need to sign up at oracle.com/startup. Startups get free cloud credits, migration support, mentorship, and a 70% discount on the most value-priced cloud in the industry. And qualifying startups can level up to take advantage of this business-boosting market connections. For any inquiries on promo codes available, please email me at rohit.c.jain@oracle.com. I'll drop my email in the chat box, and we'll share Costa's email that can answer any of your technical questions for our startup program. And we'd love to have you join our program. It's easy to get started. Just fill out the application at oracle.com/startup. And we'd like to end with a quote from our founder, Larry Ellison. Not everyone believes, in fact, most people don't believe that Oracle has the fastest cloud and the lowest cost cloud. But when you come here and try it out, that's exactly what you find out. Thank you. Passing it over to Matt.
Thanks, Rohit. Thank you, Kara. Let me share my screen now. Okay. So today, as Kara mentioned, we're going to be speaking about intellectual property, and to the extent we have some time at the end, going into some commercial contracts. I have seen some questions that have already been submitted. What we're going to do, the plan is I'm going to stop after each section and ask if there are questions that you have on that particular section. I can speak for an hour and a half straight without breathing, so I'm going to intentionally pause myself after each section. And as Kara said, if you can submit your questions for that section as we go through it, do appreciate the questions that have already been submitted, and I'll try to get through some of those. But we'll do this in real time, because I think some of the questions that have been asked already hopefully will be answered during the course of my presentation. So here's the agenda. We're going to go through 3 of the largest buckets of intellectual property rights: trademarks, copyrights, and patents. And then we'll go through some commercial contract considerations and questions that startups and Series A and B companies often have while working with attorneys. I should mention, I'm not going to give my bio or any bio of my firm. That's all in the at the end of the slide deck. What I will say that's probably not in the slide deck is that I'm the founder of my own company as well. And some of the issues that we're going to go through now, I've had to go through with my startup. So I'm a founder. We're in the seed stage. We have 2 issued patents, and our company is a platform by which you can crowdsource alternative audio commentary and then synchronize that alternative audio commentary with any video that you're watching, whether it's library or live content. So if you're watching the Super Bowl and you don't like your announcers, you could use our platform to crowdsource someone else to do the announcing. So I'm going to give some anecdotes, maybe a few war stories along the way, and keep things interesting. And as I said, please ask questions along the way in the chat function. Okay, so what is intellectual property? The key hallmark considerations for intellectual property is that they're intangible rights, right? It's not a desk, it's not a chair, it's not a car, it's not machinery. They're intangible rights that protect human intelligence and creation. And as I said, we're going to go through the 3 main buckets right now. And these are topics that even if you're not an attorney, and even if you're a technical person that's doing coding, if you're a founder or you're in the C-suite, these are terms that you should be conversant in for a variety of reasons. One, when you're speaking with investors and customers, you're gonna extend yourself out and seem very knowledgeable about it. Oftentimes, when I work with early stage companies, they will conflate certain terminology, which is problematic. It reflects not the way you want to reflect your company by mixing up terms. We're not expecting you to be attorneys, but the goal of this presentation is to explain to you those three buckets so you could be conversant in those areas. So a trademark is any word, symbol, phrase that identifies the source of the product or service. Well, what does that mean? Think of very famous trademarks that you're probably aware of, right? Oracle, that's the name, that's the trade name of Oracle, or One Valley, that's the trade name of One Valley, but it's also a trademark. It shows that Oracle's cloud computing services come from Oracle. So when you see the Oracle name or the Oracle logo or the One Valley name or logo, that indicates that the product or service is coming from that company. So other famous examples, these are really obvious ones, right? The golden arches for McDonald's, the Nike swoosh, Just Do It. There's also, you can have a trademark for sounds. So Intel, the Intel Inside, dun, 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 right? So there are sounds that could function as a trademark. Colors can function as a trademark. The bottom of the Louis Vuitton shoe can serve as a trademark. The pink Owens Corning fiberglass doesn't have to be pink, but people know that pink insulation comes from Owens Corning. So those are trademarks. Again, it's anything that indicates where the product or service is coming from. Now, a lot of people think, and some of your questions indicated, okay, I am in my seed round or I'm in my A round. Should I go for a trademark? Well, the good news is you don't have to actually apply and register to get a trademark. You get a trademark just by using the mark, quote, in commerce. What does in commerce mean? In commerce means any interstate commerce. So if you are advertising your products or services on the internet and you're using a trademark to do that, you have rights just by virtue of using it in interstate commerce, and anything on the internet by definition is interstate commerce. That's called common law rights, gaining rights just by using it. You can also get additional rights by registering your trademark. For time considerations, I'm not going to be able to go into all of the sort of ins and outs of trademarks, but I will say that even if you're not using the trademark, if you have a bona fide intent to use the trademark in the future, you can file what's called an intent to use application, which is basically reserving your right to use that name. And then as long as you use that name within a period of time, usually within 12 months, you get to file what's called a statement of use. So if you're thinking, a lot of you in the audience today are already established companies. Maybe you have a trademark, maybe you have a registration, maybe you don't, maybe you have a product name that you're considering trademarking. My opinion is for really key product names, for your trade name, it's worth clearing the rights, and I'll describe that in a minute, and it's worth obtaining a registration for really key trademarks. The name of my company is called Fansmit. F-A-N-S, like fans, because it's for the fans, MIT, M-I-T, as in transmit. So it's the fans transmitting a broadcast. We have a trademark for Fansmit. We originally filed it as an intent to use application because we didn't want anyone else using that name. And what that does is that reserves your right to use the name. No one else was using it. And then once we started using it, we filed the statement of use, and now we have a federal registration for Fansmit. You don't get a trademark. A lot of people ask this question. Okay, well, I have a trademark. That means nobody else can use that trademark, right? Not actually. What happens instead is you file in discrete classes of goods and services. So for computers, for example, you may be in a particular class. If you are doing media and entertainment services, that's in another class. If you're doing consulting work or business development or software development, that's in a different class. So again, you don't get a trademark in everything. You get a trademark for discrete classes of goods and services. Here are the registration requirements. It can't be the trademark in order to register it with the PTO, which is the Patent and Trademark Office, which is where you would register patents, obviously, Patent and Trademark Office, and trademarks. You would register a copyright, which I'm going to get to in a minute, in the Copyright Office. So here are some of the requirements to register a trademark. So it can't be generic. So for example, thermos, right? Thermos, and we'll get into how you lose trademark rights. Thermos used to be a trademark, but people genericized it. They started using that to describe the product or service. So as soon as the trademark no longer functions to identify the source of the good, and then instead identifies the good itself, like a thermos, then you become generic and you can no longer use it. So generic would be something, Apple, right? So Apple computers and Apple iPods, iPads, iPhones, iWatches, right? If you were doing an Apple stand, right, that would be generic for the Apple stand. It would just merely describe what you're doing. But Apple, used in connection with computers and media and entertainment and those sorts of things, is not generic. It doesn't describe the good or the service. So apples for Apple stands probably doesn't work. You don't want to hit it, you don't want to hit the nail so far on the head that your trademark is describing exactly what you do. It can't be immoral. So there's been a lot of stuff in the news. I don't know if there are any football fans out there, but there have been lawsuits over the Washington Redskins, whether the Redskins trademark is immoral. So a trademark, in order to get registered, can't be immoral. You can't use curse words in it. You can't denigrate people with the name of it. You will not get a trademark if it's used in that capacity. The mark that you're trying to register can't be identical, and here's what's really important for trademarks, it can't be confusingly similar to a prior registration. What does confusingly similar mean? That means to a reasonable person that the mark, when viewed either in sight, sound, or meaning, is similar to another mark. Confusingly similar, that's the standard for getting a trademark registration. So my firm, there's 350 attorneys across the country. We represent 2 guys and women in their garage, all the way to Google and Amazon and everyone in between. Our technology group works with a lot of startups, ranging from angel financing, seed financing, Series A, all the way to Series F, all the way to IPO. And one of the questions when a founder comes to us and she says, okay, I've got a great name for my company. I want you to form the company, and I'm going to be VC backed. So I want to do a Delaware C Corp. Here's the name. Please form the company. Please, get us the name. That's not exactly how it works. You can do that. The problem is if you form your company without doing any kind of research as to whether or not someone has a registration, or if someone has common law rights that are superior to yours, right? Remember, we talked about earlier how you don't necessarily have to have a registration to get trademark rights. You get a trademark just by using the name in commerce. So we've had some people who have formed companies, operated for a year or two, spent tens of thousands, if not hundreds of thousands of dollars forming their company, naming their product or service, and then a year later they get a demand letter from some company out in Wisconsin saying, hey, you're using the exact same name that we have. We need you to stop using that mark. We need you to stop using that name. And the client comes and said, hey, I looked at the Patent and Trademark Office and there was no identical mark for that company. Well, if you've been paying attention, there's a few things wrong with that. One is it doesn't have to be identical, right? Remember, it's confusingly similar. So if it looks, sounds, or means something very close to the other mark, could be a problem. And the other thing is you don't need a registration. So they were using this mark. It wasn't Wisconsin. I'm just making up, facts to protect the innocent here. But it was a company that had been using the mark in commerce for years and years. And if the client had just done a search on the internet, they would have seen that there was a company out there that had a very similar name to theirs. So what we advise when you're coming up with your company name, or you're going to launch a product, or you're going to do a big campaign, marketing and media campaign, do a trademark search. Now, oftentimes you could do your own in-house thing, but we recommend going to a law firm that specializes in intellectual property to conduct these trademark searches. So you can do what's called a knockout search, and that's a preliminary in-house search that we would do that would look at the USPTO, Patent and Trademark Office. It would look at a variety of different databases that we subscribe to, and it would look on the internet. And we have paralegals that do it, so it's pretty cost efficient. It's on a fixed fee basis. And we do it and we say, okay, red light, don't do it. There's something that is clearly a problem. Or we may say, nothing really showed from our preliminary search. We recommend we now do a full search, which is a couple of $1,000s. We recommend that for names of the company or major products. Things that are not as important, maybe you can get away with just doing the preliminary screening and not do the full search. To the extent you have the money, we do recommend doing the full search. And then, again, our clients, sometimes if they don't do searches and they just start using a name in their marketing, sometimes they will get demand letters alleging that their name or their product or service is infringing. So infringement occurs when any consumer, right, just the ordinary, Jane and John, are confused as to the origin, the source, the endorsement, sponsorship, or the affiliation. So if I, instead of calling my company Fansmit, called my company Nike, there would obviously be a problem. We would get a letter from Nike's attorneys saying, stop or else, and we would have to stop. Now, because it's Nike, we would stop because Nike is a famous trademark. However, if it were, let's just say we wanted to call ourselves Joe's Garage, right? Joe's Garage, if they have a registered trademark, is probably for car services. It's probably not for crowdsourcing alternative audio commentary. So if the trademark is not famous and you're in a completely different class of goods and services, you're not doing anything remotely close to what the other company is doing, and they send you a demand letter and say, hey, you're using the same name that we are, you better stop. Oftentimes, if you go to an attorney who understands trademark law, we can come back and say, yeah, the marks are similar, but it's different classes of goods and services. You're targeting different consumers. You are in different classes. It's completely different. No one is going to be confused. So if you get a trademark demand letter, it doesn't mean you have to immediately stop. Take a breath, call your attorney, and make an analysis as to whether or not you need to stop. We talked a little bit about the registration. Again, I'm only talking about the United States today. You could file either a use application or an intent to use application, as I described. You would file it with the USPTO, again, Patent and Trademark Office. Some countries, like the US, allow for electronic filing. So everything we do is electronically. You get the filing done very quickly. Registration, unfortunately, takes a little bit longer. So it's usually around 1 year from the time that you file it until the time you get the actual registration. And sometimes along the way, you don't just get a registration. You may initially get rejected in something called an office action. So an office action is the trademark examiner saying your trademark is confusingly similar with another one that's already registered. It is generic, it is immoral, it is merely descriptive. There's a whole bunch of reasons why you can reject a trademark. If you get rejected, you have 6 months to appeal that decision. Sometimes, when you go to an attorney, the attorney may say, you have absolutely no chance of winning this, don't even bother. Or the attorney may say, you've got a great shot, let's do it. The cost associated with responding to an office action really varies depending upon the nature of the rejection. So again, that's something that we would recommend talking to trademark counsel to determine whether or not it makes sense to file an appeal of that office action rejection. And hopefully, if you've done your preliminary analysis or your full trademark search, you will have known that there might be some impediments to you getting your registration. So you would then probably know about these things beforehand and hopefully have arguments how to overcome the rejection. Useful tip for folks following at home: you don't need a registration to claim trademark rights. We've already talked about that. And you don't need a federal registration to use the symbol. Here are the symbols that you should be using. If you have a federal registration, that's where you use the R in a circle. If you are not federally registered, but you're using the mark in commerce and it is for a product, you would use a TM. You could put it in a circle if you like. I'm not a graphic designer, but you could use it with or without the circle. Or if it's for a service, it would be SM, right? So One Valley's financial services, right? So One Valley, if they didn't have a federal registration, they could put an SM next to their name. Oracle has both products and SaaS products. So they may, for a certain product, they may use a TM, they may use an SM, but I can assure you that Oracle has federal registration, so they most likely use the R symbol. I talked earlier about ways that you can lose trademark rights. We talked about Thermos and how Thermos used to be a trademark, but then they didn't really police the usage of it, so it became generic. So as soon as something becomes generic, you lose your trademark rights. If you don't use the mark in commerce, you lose trademark rights. If you fail to police it, or if you license it to people and you don't have quality control restrictions, or if people are using it without your permission and you don't go after them, those are ways that you can lose trademark rights. So if you have a federal registration, you need to make sure to protect it. It's a valuable piece of intellectual property. So you've got to maintain it, you've got to defend it, you've got to do all of those things so that you don't lose your trademark rights. I'm going to pause now because that's the end of the trademark section. So if anyone has any questions, now would be a great time to submit them via the chat function. And I'll pause for a second to see if there are any questions, and if there aren't, I'll go on to copyrights.
Matt, I have a question.
Sure.
What about website domains? Are they protected at all around by your trademark?
So the domain is not protected as a trademark in and of itself. You would file, now you could file, think, stamps.com is a domain, but it's also a registered trademark. Pets.com, eBay is not a domain, eBay is the name of the company, but sometimes you can get the .com. Now what will happen is you will have to, it's called disclaiming. A disclaimer means that you can't claim exclusive rights to a portion of the trademark. So you can't say I own .com, but if the .com is part of your mark, you can have pets.com and you would disclaim the .com. But filing for a domain name and getting it set up with the registrar is not in and of itself a trademark of the full domain. It would be a trademark of, again, pets is sort of generic. That's why they got pets.com, was because you can't go out and say, all right, no one in the world can use the word pets, right? So that's why they did pets.com. But ebay.com, eBay is not merely descriptive. So they have a trademark for eBay, but they don't have a trademark for ebay.com. Does that make sense?
Yeah. There are a couple other questions that are popping in.
Sure, so I'll answer these. So thank you. How do we trademark colors? Great question. So the color has to signify the source, and it's got to be limited to narrow classes of goods and services. So as I mentioned, Owens Corning fiberglass is a registered trademark. It's pink. You would file an application, and when you file the application, you would claim exclusive rights to pink, to the color, and you can't claim black or white. It has to actually be a color. So if your color palette is black and white, you're sort of out of luck there. But if it is the color and it identifies the source, you can't just say, I own pink. You have to get what's called secondary meaning. So Owens Corning, people know that if you buy fiberglass and it's pink, that it's from Owens Corning because they used it for a number of years. And you would file a trademark registration just like you would for any other registration. You would claim pink in the application. How bad is it to use these marks if you don't have them registered, say to scare competitors and using a name while you secure exclusive rights? So what I would say there is, if you're actually using a mark in commerce, there's nothing bad about that unless you're infringing someone else's mark. So if you want to use a name, even before registration, again, you get trademark rights just by virtue of using them in commerce. So just using it, even without an application or a registration, you have trademark rights, and you could use the TM or the SM. You don't need a registration. I encourage people for the important ones to get a registration because there are certain rights that come with registration. You get, it is now assumed that you have trademark rights, and the other side has to now disprove that you don't have trademark rights. So it's called a rebuttable presumption. There's a rebuttable presumption that you own it and that it's valid. So there's a lot of really good benefits to getting a trademark registered. How do you police your trademark on a global level? These are great questions. We get these all the time. So thank you for the questions. You can engage a law firm. It is expensive for a law firm to do the actual policing. So what the law firm will typically do, and you don't need a lawyer in order to do this. You could do this on your own, but we find it's better to work together with your counsel. You can hire third parties who monitor the web, they monitor social media handles, they monitor domain names, they monitor the internet. And whenever someone tries to apply for a trademark that's confusingly similar to yours, if they try to register a Twitter handle or an Instagram handle or create a domain that's anything near yours, a red flag will pop up. Your counsel will be notified. We'll talk with you and we'll say, hey, there's someone out there that's using something that's really close to yours. And then you decide, do I want to follow up with them and send a demand letter? Is it far enough away, or is it in a different class of goods and services so people really aren't going to be confused? So there's a way to do it where you're not going to lose sleep over it. You can hire a third party to help monitor for you. And then we got two more, and then I'll move on to copyrights. I'm just mindful of the time. When it asks for the description on what the trademark would be used for, what is the best way to approach it? I have seen trademark attorneys written descriptions, but it doesn't seem like natural language. There is absolutely nothing natural about a trademark description. You are absolutely right. There are approved classes of goods and services that the USPTO, Patent and Trademark Office, I'm trying not to speak in acronym, that if your goods and services fall within those descriptions and you use those pre-approved descriptions, right? Software as a service, computer development services, financial advisory services, things that are already approved by the Patent and Trademark Office, you will not get rejected for the description of the goods and services being vague or overly broad. So sometimes our clients will say, we want to use the standard definitions, we're okay with them, and you use them, and as long as your application doesn't fail for any other reason, you'll get approved. You won't get dinged for using an inappropriate description. But there is nothing natural about these descriptions. So again, we're going to get into copyrights right now, so it's a good segue. What you can do if you're not using trademark counsel is you can go and you can look at your competitors and see if they have a registration, and you could look at how they've described their goods and services. And you can, I'm not saying copy it word for word, but you could model your description after that, as long as it's accurate. That's not really copyrightable text that's in the body of a registration. So again, nothing natural about it. You probably want to work with an attorney. To the extent you don't, you may want to look at what competitors are doing, and you can look right in it's uspto.gov, G-O-V, and you can go under the search function there, and you could look and see what your competitors are doing and what registrations they have. And then the last one, does it help to have a trademark registered in another country? Yes, if you are going to be offering your goods and services in that country. There's a whole nother entire lesson that I can give just on international trademark law. But what I will say is there are treaties that the US has with various countries, which allows for reciprocity. So if you have a trademark in the United States and it's registered, all you have to do is a filing in that foreign country, and they will not do an examination of your mark. They'll say, hey, if it's good enough for the US, it's good enough for us, and they give you the registration. There are ways that you can register your trademark. It's called the Madrid Protocol, where you can register in all of the EU countries. So instead of going in individually to each country, you can do something under Madrid. There are benefits and downsides to doing the Madrid Protocol, but it is something worth exploring if you're doing work internationally. So thank you, all great questions. I'm gonna move on to copyrights now. I don't know if Kara mentioned it, but I can go a little bit beyond 3 o'clock. I'm going to hustle through the next 2 sections because I would like to get through everything, and then to the extent there's time, I'll sort of flesh it out a little bit more for you. Okay, copyrights. People often think that I have an idea, I've got a great idea, I'm going to copyright the idea, or I'm going to patent the idea. You cannot copyright an idea, you cannot patent an idea. What copyright protects, it's called the idea expression dichotomy. Big words, what does it mean? It means copyright does not protect ideas, it protects, and I'm going to read this now and then I'll break it apart for you. It protects an original work of authorship fixed in a tangible medium of expression. What does that mean? An original work of authorship means you can't copy someone else's stuff and say it's original. It's got to be new and it's got to be yours. What is a work of authorship? There's a bunch of different works of authorship. It could be any kind of text, books, white papers, specifications, descriptions, documentation for your software, code, source code, object code. It can be photographs, videos. I don't know all of the different industries that folks on the line are in, but I'm trying to give you sort of a broad brush as to what that original work of authorship means. And it needs to be fixed in a tangible medium of expression. So what does that mean? That means you gotta get it down on paper. You've got to record it. You've got to take that photograph. So if you have code and it's only sitting in RAM, right? Random access memory, that's not fixed. It's transient. It's ephemeral, right? It has to be something that is actually copied and fixed. And I'm trying to find another word for fixed, but you get my drift, right? It's got to be written down. It's got to be recorded. It's got to be tangible and there for you. And what do the rights of copyright give you? It gives you exclusive rights to do certain things. It gives you the exclusive right to copy. It gives you the exclusive right to publicly perform. So for anyone in the audience that is in any way creating or exploiting music, there are 2 copyrights for music. So to the extent you are using songs on your website or in advertising or in your products or your videos, very difficult to clear music rights because there are 2 copyrights. There is a copyright in the actual sound recording, right? What's recorded. And then there's also a copyright in the musical composition. And one of the rights for a musical composition or a sound recording is your ability as the copyright owner to publicly perform that musical composition. You could play the song on the radio, you can play it in a video, those kinds of things. Publicly distribute, I think that's pretty obvious what that means. Create derivative works of. What's a derivative work? A derivative work is something that is based upon or derived from the original work. So if I wrote a book, the book is a work, it's fixed in a tangible medium of expression, and I have the exclusive rights to that book. If I now want to turn that book into a movie script, the script for that movie is a derivative work of the book because it is derived from that book. So that's what the derivative work means. So these are the exclusive rights that you have as the copyright owner, which you can license to third parties, which if you're using someone else's copywritten work, you would have to license it from them. Like trademarks, it's good news. And I know that these were already in the series of questions, so I'm going to answer it now. Do I have to file for a copyright registration? Like trademarks, you don't. You have a common law copyright from the moment that the work is created and it's fixed or recorded in that tangible medium that we've discussed. So I'm a software developer and I'm coding in Java. Someone asked about Java and how do you protect the scripts? How do you protect the software? You protect it just by writing it. You have a copyright in writing the software. That's it. That's all you need to do, full stop. Now, if you want to sue someone for copyright infringement, you need a registration before you can sue them. There are a lot of benefits for getting your copyrighted work registered. If we're talking about website copy or code for stuff that's not really terribly novel, not really that important, I wouldn't spend the time or the money to copyright it. You have a copyright already. I wouldn't register it. Sorry, whoever's not on mute, if you don't mind muting, I'm just getting a lot of background noise. Thank you, Carl. So if it's an important, if it's a book, if it's a screenplay, if it is that killer software that you want to copyright, worth considering the copyright. Now, one of the really difficult areas of the law, and I know a lot of folks in the audience are software based. The question is, do you want to copyright the software? Do you want to patent the software? Or do you want to rely on something called trade secret protection? And I just want to unpack that because I think it's important for the audience here. When you file for a copyright, you have to actually disclose the work. It now becomes publicly available by filing it with the Copyright Office. If you want to file software, you don't have to disclose all of the software, but you do have to disclose certain code. You're allowed to redact some code. You're allowed to take out chunks of the code, but you're going to have to disclose some of it. So some people decide, I don't want to disclose any of my code. I have a copyright from the moment I fix it. I'm not going to copyright my software. And that is a very valid approach. And if someone is infringing your software, what you can do is you can file for the registration after the infringement. There are a lot of benefits to having a registration before someone infringes your software. But again, not everyone wants to copy their software, especially if you're creating a lot of it. You can also patent software. I have 2 patents for my company for the synchronization technology. So we patented the method of synchronization. We did not actually patent the code, but you can patent code. I'm going to get into patents in a second. And then the third way you can protect your software or your algorithms or your APIs, whatever it is, your configurations, whatever you're creating, is through trade secret. Think the formula for Coca-Cola. That's a trade secret. It's not patented. It's not copyrighted. It's a trade secret, which means it's confidential information that Coca-Cola will go to the ends of the earth to protect. They put non-disclosure agreements in place. They take a lot of time, effort, and precautions to protect it. The benefit of having trade secret protection is because it lasts for as long as you maintain the secrecy of that invention. So we represent Google. We do patent work for Google. I'm not disclosing anything that's not already public, but Google decided they were not going to patent or copyright their search algorithm, because if you patent it, you lose that after a certain period of time. If you copyright it, you lose it after a certain period of time. So instead, they have trade secret protection for their algorithms. So they basically have perpetual protection for their algorithm, their search algorithm, which is obviously one of their core assets. So that's some of the considerations you should look into. We talked earlier about copyright vesting when it's created. I didn't really get into this, but for those of you who are seeking either seed, A round money, B, whatever it is you are looking for, or if you're looking for an exit at any point, it's really critical to paper all of these relationships with your employees and with any vendors that you hire. So the rule for copyrights is, if I'm an employee and I am working within the scope of my employment, so you hire Jane to be a software developer in your company, and Jane creates code for you, even if you have no agreement with Jane in writing, the company will own that code because she created it within the scope of her employment. The problem is trademarks don't operate that way and patents don't operate that way. If I create a piece of IP and I don't have it in writing that the company owns it, that means that the individual retains the rights to that. And you can fight over whether or not you have a license, whether it's an exclusive license, whatever. Best practice is anybody, including the founder, right? Anybody that touches any intellectual property for you, you should have a written agreement that says it's work for hire. To the extent it's not work for hire, the contractor or employee, these are the magic words, hereby irrevocably and unconditionally assigns all right, title, and interest in and to such invention, work, patent, intellectual property to company, right? You want to make sure that the company owns all this stuff, because I could tell you, I do a lot of corporate work too on the intellectual property side. And for startups that didn't start with us, that either did a lot of it on their own or worked with another law firm, if you don't have the right documents in place, you may not own the thing that you think you own. And that's a problem. Investors don't want to hear, we don't really own it, right? You got to now go back and get those rights. And you can't just go back and get those rights. You got to go back and get those rights. And you got to tell the person, hey, we never really papered that. I know that we were supposed to own it, but now we need to paper it. Well, why didn't we need to paper it now? It's been like this for 3 years. Well, I got someone that wants to give me $1 million for my A round. Okay, what's in it for me? They're going to want some money. So paper it early, paper it correctly. Copyright. You can put this on your software, right on the splash screen. You could put this on your white paper. You could put this on your website. C with the circle, that indicates we have a copyright. 2020 is the year that it was first created. XYZ company. I went pretty creative here with the trademark for XYZ company, but if you create something new and you create it in the next 15, 16 days, see with the circle, 2020, Oracle Inc., right? Oracle is putting the world on notice that they own the copyright. We already talked about registration being optional. It's less common than trademarks. You will see trademarks registered much more commonly than a copyright. But there are certain things that you want to copyright. Anything that's really critical. If you're a writer and you do a book, if you're creating really extensive software, you might want to consider copywriting that. It's something that will bring you benefits down the road. Just in the interest of time, I'm going to go very quickly through fair use. I'm gonna give you this in literally 2 minutes. questions we get asked all the time. I saw something on the internet, we want to use it, and we're going to put it into our slide deck. We're going to put this into our code. We're going to put this into our white paper, in our marketing. We're going to use the music in our video, right? And it's fair use, right? Because it's already on the internet. No, right? It's copyrighted. If you don't have a license to it, chances are there is no fair use. Fair use is what's called an affirmative defense, which means if you infringe someone else's copyright, you are presumed to have violated their copyright, and then it is your responsibility to prove that your use was fair. And there's a 4-factor test to determine whether or not a use is fair. So unless you are commenting critically on something, you're a news outlet, you're a teacher working in a grade school or something, chances are the fair use defense is probably not going to work for you. I very rarely give people the green light and say, oh yeah, that's definitely a fair use. So those are the 4 considerations. It's what's the purpose and character of the use, meaning your use. Is it for a commercial purpose? If it's for a commercial purpose and you're using it, chances are it's not fair. What's the nature of the copyrighted work? Are you borrowing stuff from a book, or are you summarizing a news article where you're not taking it word for word, but you're summarizing something that might have happened? So what's the nature of that underlying work that you're borrowing from? What's the amount and how important is the stuff that you're taking? Anyone in music might think, there's this misconception out there that if I only take 3 or 4 bars of something, it's so little that it's not an infringement. There is no such test. There is no de minimis test. If you take something that's critically important to the work, like the hook, the bass line, something that, really known for, or like the most important part of a book, or the most critical piece of a line of code, it doesn't matter how little it is, it's really critical. So the courts will look at that. And then they'll also look at what's the effect of your use on the potential market for the copyrighted work. So for anyone that's old enough to remember Napster when it was bad, right? They would take entire songs and let people upload them, and then other people could download them. So I can go on and I can listen to my favorite music, and it completely eliminated, people were no longer buying CDs. For those of you in the audience who remember what a CD is, right? People were not buying music anymore or signing up for Spotify, because you could just go to Napster and rip it free. So that completely eviscerated the market for legal music, and the courts found that not to be a fair use. First sale doctrine allows for subsequent transfers. So if I buy a book from Amazon and I decide later on that I want to sell the book, first sale means anyone who buys that original work can resell that work. There are some important exceptions to that and things that you would need to work through, but that's what first sale doctrine means. Proof of infringement. So we talked earlier about trademark. And again, for those of you following at home, trademark is if it's confusingly similar. For copyright, it is whether the work that you did is substantially similar. So if you take someone else's work, the plaintiff, the person who is bringing the claim against you, would need to prove that you had access to the work. If they never published it and it was only in their basement, and you created something that was very similar to it out of your own mind and never had access to it, you couldn't have copyrighted it. You couldn't have infringed the work because you didn't have access to it. So they would have to prove access and substantial similarity. So you will often see software companies include in their software bogus lines of code or things that are intentionally incorrect, because if someone copies it and then you sue them, you will be entitled to get access to that code, and then you'll compare yours with theirs, and there'll be that, nonsense code in there, and you'll say, okay, well, why did you put that in there? And they'll say, I have no idea, right? So that's one way to create a way for you to prove infringement. All right, so I'm going to pause only for about 15 seconds on this, and let me know if you have any questions on copyrights, and then we'll dig into patents right after.
I have a question. Can you copyright pitch decks?
Yes, the pitch deck is copyrighted the moment that you create the pitch deck. I don't think I would file a registration for a pitch deck. And the pitch deck will have a variety of different things, right? You're going to have your name in there, not your personal name. You'll have the name of the company. So the name of your company would be protected by trademark rights. But if someone were to take your work, your deck, and use your deck identically, they will have infringed your copyright. Now, again, I started out by saying copyright does not protect ideas. It only protects expression. So people think, all right, I've got this great idea for a company and I'm going to send out a pitch deck, and someone copied my idea, they've infringed my copyright. No, they've infringed your copyright if they copy the words and the pictures and the logos on your deck, right? So how do you protect ideas? That's something that we get asked all the time. You protect your ideas through confidentiality agreements. So if you've got a really interesting idea, and investors will not sign non-disclosure agreements, so I wouldn't even ask. VCs will not sign it. You'll look sort of Bush League if you do that. But if you're working with a vendor, for example, and you need to explain to the vendor what you're doing, and the only way to explain it is by giving them some certain confidential information, you would want to have a non-disclosure agreement with them. That's how you protect ideas, is through non-disclosure agreements. We're going to get into patents now that protect inventions, but for trademarks we've talked about, and then for actual expression, you would protect that through a copyright. What is the cheapest way to copyright something, and can it be done without a lawyer? Cheapest way to copyright something is just by creating something. Again, you have the copyright just by creating it. I would encourage you to use that that legend that I have a couple slides prior that I'll go to now. See that little C in the circle? Use that. Obviously, don't use XYZ. Don't use 2020 if you create it next year, but it should be the name of your company and the year that you first created it. Now you have a copyright. What is the way that you can copyright it without using a lawyer and get a registration? You can go to copyright.gov, again, G-O-V, and that will walk you through the process of filing a copyright. Copyrights are much quicker, much cheaper, and much easier to get than trademarks and patents. Trademarks take about a year. I recommend that you use an attorney for that. Copyrights, and then they cost, you know, thousands of dollars to get a trademark. To get a copyright, you're looking at only a few $100s, and you can get a copyright in just a few months. And you normally will not get rejected for a copyright. I mean, it really has to be something that is not really original or is not protectable under copyright law, like a recipe. For example, you can't copyright a recipe because it's an instruction. All right, the last one that I'll answer, and then I'll go to patents. Can a process be copyrighted, i.e. a business model, revenue model for an existing concept, maybe a premium version of a product or service? So no, processes are not copyrightable. They are not trademarkable. They are patentable. So you can have a business method patent, and there are a bunch of those. They have been sort of diluted over the years, but if you have an invention or a business method, that would be under a patent. I'm going to go through patents now. I will not have a chance to go through commercial contracts, but I will go through some very high level concepts that will hopefully be helpful for all of you. So a patent, again, protects inventions, does not protect ideas. So for you to get a patent, there are 3 statutory requirements. The patent needs to be useful, right? So it has to have utility. It has to be novel. So that means that the original invention needs to predate any knowledge or use within the United States. So that means, what does that mean? That means if you release your product publicly and you don't apply for a patent within 12 months, it's no longer novel. So if you disclose it publicly, if you describe it on your website, in a white paper, in an article, if you release the product, and you wait more than 12 months, it's no longer novel. And it's got to be non-obvious. What does non-obvious means? It means when the patent examiner looks at it, will the patent examiner say, hey, you know what? There are other people that are schooled in the art, right? So if it's an electrical thing or a software thing, any reasonably skilled developer, she would know how to do this because it's so obvious, right? It cannot be obvious. So those are the 3 criteria for patents. Here's the patent process in one slide. Our firm, as I said, we do patents for, the most iconic Silicon Valley firms, all the way to startups and everyone in between. It's about an 18-month process, unfortunately. Here's the process. The process is you're going to give us what's called a document disclosure. That's the initial filing with the patent office to establish the record of the idea. And by idea, I mean the invention. The Patent and Trademark Office, once you get that established, the importance of establishing that is, under the United States patent law, it used to be first to invent. It's no longer first to invent. It's now first to file. So if you have a patentable invention, it's really important to talk to a patent lawyer and see, hey, is this something that we should get down and patent? Because you don't want to have someone else file before you, and you don't want to disclose it publicly or use it publicly and have that statutory bar that I was talking about. We'll do a patent search, which will see if there's anything out there that's similar to what you're doing. And then the inventor, that's the person who is actually inventing it, will work with us or your counsel to file the actual application. Again, I'm going to go back to what we said earlier. It's absolutely critical that if you have employees or vendors who are creating intellectual property for you, that you have that language that assigns everything to the company, because if you don't, and they invent something and it's patentable and you don't have that assignment, the inventor owns the invention and only the inventor can file for a patent. So it's absolutely critical. If you take nothing else away from this hour and a half, I would say make sure that your agreements with your employees and your consultants, contractors, independent contractors, vendors, whatever you call them, make sure that there's language in there protecting your IP. The patent office will examine the patent and they'll look for these 3 things that I talked about. Is it useful? Is it novel? Is it non-obvious? Chances are, I would say 99 out of 100 times, you will get a rejection. And just like for trademarks, it happens all the time, and it's not a bad thing. It gives you the opportunity to respond to that office action. And what we typically do with patents, you oftentimes want to get as much as they will give you. So we will draft a pretty broad patent that will get rejected. And then in the office action response, you sort of whittle it down a little bit so that it passes muster. You don't want to go so narrow with your patent in the claims. That's what they're called when you file a patent. There are claims within the patent. If your claims are so narrow, they're going to be useless. So you want them to be as broad as possible without you never getting approved, right? So it's an art of drafting trademark claims. It's an art for drafting patent claims. And I would say if you're doing patents, you should really be working with an attorney. Patent grant, again, it could be anywhere from 12 months to 18 months to 24 months, depending upon if you get office actions, depending upon the field of use you're in. One of the questions as I was perusing before the session was, why the hell does it take so long? Well, it takes so long for a few reasons. One, patents are extremely complicated, and there are millions and millions and millions of patents. I'm actually, is really cool. One of my clients, her father actually got the country's 10 millionth patent. So his name is on the 10 millionth patent. So there's literally millions of patents that the Patent and Trademark Office needs to go through to determine whether it's non-obvious, whether it's novel. So there's a lot of patents. They're very complicated, and you're dealing with the government. I worked for the Department of Defense for 7 years. So anyone that needs a good government contract attorney, I do that as well. And having worked for DOD for 7 years, I know that the government does not operate at the speed of light. So you've got three things against you: complicated, lots of information out there, and working with agencies that are not really known for burning the midnight oil. People think, okay, I have a patent, that's great. I can now do everything. Like, no one else can do what I'm doing. I own the world, right? Well, again, not really the case. Patents only enable you to do one thing, and it gives you a monopoly to prevent someone else from practicing your invention in the country where you have a valid patent. Let me unpack that real quick. What that means is, if I have a patent in the United States and someone is infringing my patent in Germany, there's no patent infringement because I don't have a patent in Germany. So if you get a patent in the US, you may want to file in other places where your products and services are sold. What does it mean, practicing an invention? You have a patent for your narrow claims. You don't have a patent on, I just created a new SaaS product, so now no one can do SaaS, right? That's not how it works. It's, I have a patent on the invention that's described in my claims. So that's why it's really important to work with good patent counsel to draft very tight claims that will protect you if someone's doing something that is similar. You may often hear of people designing around a patent. You can do that. As long as you're not violating the claim, you could design around a patent. So it's something to consider. Another reason why Google didn't disclose its search algorithm, because once it's out there, people can now design around it. So that's a consideration that you need to look into. And once you own your patent, it's great because now you can license it. You can make money by licensing your patent out to folks who are not going to compete with you, where it's not going to be detrimental to your business. But if someone is doing something that is very similar conceptually to what you're doing, but they're doing it in a completely different field, you may want to license that. We were approached by a hedge fund to license our patents for online gaming and gambling. And we thought about it. The problem is they wanted an exclusive license that was going to now preclude us from doing anything with the league. So we've talked to some of the leagues, like the NBA, for example, and the NBA won't want to work with us on using our patents if we've granted someone else an exclusive license to online gaming or gambling, because the leagues and the teams are now getting into that. So we opted not to license our patent on an exclusive basis because it would preclude us on a go-forward basis from monetizing it or using it ourselves. Here are some of the considerations that you should look into. I'm not going to go through all of them now because we just don't have time, but here are the things that you should consider whether or not you even want to file a patent. Because again, they take a long time, they're very expensive. Sometimes you may not even want or need to have one. Here are some of the things you should look at. We decided to file for our patents even before we were funded. Well, we're not funded actually. So if anyone knows a good VC out there, point them my way. But to the extent you have the money to do it, I view it as potentially worthwhile because VCs actually do care. Do you have protectable IP? So we have a trademark, we've got 2 patents, and by having those patents, we have now walled off our competitors for the claims that are covered in our patent. So it's not easy to do what we've done. We're able to synchronize to a fraction of a second. So we've got some really amazing technology, but the technology in and of itself, you will be able to create things, you'll be able to design around this. There are different ways to slice the bread. So we decided it was really important for us to protect our IP, to go to VCs, and it was important for VCs that we've been talking to and are continuing to talk to, that we have some protectable IP. So here are some of the considerations that you should look at when deciding on whether to file a patent or not. I'm gonna skip the commercial contracts. I'm offering Rohit and Kara now, to the extent there's a demand for it, I'm happy to do another session where I talk exclusively about commercial contracts, but I do want to highlight just a few things here. A lot of folks online, because again, this is we're talking with Oracle and we're talking about their SaaS products. If you have a SaaS product, that is a very different agreement than if you have software that you license to people on-prem, right? On-premises licensing, where they'll install it behind their own firewall. So to the extent you have a SaaS product, it's a very different agreement than if you are licensing your technology or your products. Here are some of the important considerations when you're licensing out your product or when you're doing a SaaS model. Are you licensing it or are you providing it as a service? As I just said, there are major differences between the two. Is the right that you're granting to them exclusive or non-exclusive? Exclusive means they are literally the only ones who can use the technology. As I just mentioned, the hedge fund that wanted to license our patents, they wanted to license it on an exclusive basis, meaning we couldn't even practice our own inventions in that category. So that was a problem. Non-exclusive means anyone that we elect to license it to can use it. So obviously it's much more beneficial if you're able to license something on a non-exclusive basis as opposed to an exclusive basis. If you ever see the words exclusive and they apply to you, red flag should go off, right? They better be paying you a boatload of money to get some kind of exclusivity, or you got to be in an exit situation where you're just looking to offload something, right? Like, do exclusive deals very, very sparingly. Territorial restrictions. If I license something to someone, right, if I'm licensing my software, do they have the right to use the software worldwide? Or is it just within the United States? Or is it just within the particular state where they operate? Is it a term license, meaning I'm granting you the license to use my software or my, my song or whatever it is that you're licensing? Is it for a year, 5 years, 10 years? Is it on a perpetual basis? Is it a seat license or an enterprise license? Seat means individual people. Enterprise means it's across the entire ecosystem. When you're engaging people, we already talked about, to the extent you can do it, it's always beneficial to own any IP that they're creating for you. To the extent you are providing services, these are some of the considerations that you should look into. Can you retain ownership of the work product and only license it to them? Are there non-competes in there or non-solicits? A non-compete means Fansmit hired a developer to create our MVP. We didn't want our developer doing anything else in alternative audio commentary. So there's a non-compete in there that says, while they're creating software for us, they can't create any similar software for any other alternative audio commentary company out there. And there are some, believe it or not. So these are important considerations, both when you're receiving services or providing services. Here are different ways. So if you have your own product and you're going to use a third party to monetize or commercialize it, here are the different types of agreements that you could put in place and some of the important considerations for each. Just really quickly, reseller. A reseller, what that means is I am going to actually buy a license to your product and I'm going to resell that to somebody else. So if you license your product to, I don't know, banks, you may hire an intermediary that has relationships with the banks, and that intermediary would license your software and then resell that software to the bank. So you would not have a direct contract with the bank, your reseller would. Sales reps, a little bit different. That's when you are a startup and there are third parties that have connections to the Walmarts of the world or the JP Morgans of the world or the Oracles of the world, and you want to have the contract directly with the customer. So you engage this person, he or she, as an outside sales rep. So they will go out and they will market and promote your product, but the contract will be between you and the ultimate customer, usually done on a territorial basis, and it's usually commission based. I'm not going to get into OEM or joint development agreements or subcontracting. Take a look at the bullets. Different ways that you can work with other third parties to commercialize. I wanted to go back because I do see there's a few questions, but one of the things that I wanted to highlight, there were some questions that were presented before the session here, and one of them was, yeah, how do I know if I'm working with the right attorney? I guess there's a few answers. One is, if you're working with a guy named Matt Savari, you're working with the right attorney. So I would encourage that at any point you can. No, but in all seriousness, there are some clients that are the right clients for us, and there are some clients that are the wrong clients for us. The right clients are the clients where we will add value and do it in a way that is efficient and economically rational for you. What does that mean? That means that there are some startups that literally have no money and need so much legal work that if they were to come to us, we would break their bank, their non-existent bank, just by doing basic stuff, right? Like, good legal work costs money. And good lawyers are, my opinion is, I don't want a generalist. One of my friends, he couldn't afford us early on in the stage of his company. He worked with a solo practitioner who thought he knew everything. He formed the company, he did all their corporate work, did their intellectual property. Now this company is going for their A round. There are massive problems. So what I would say is, interview your attorneys, not in an adversarial way like you're deposing him or her, but does the attorney actually handle the stuff you need? Or does someone in that person's firm handle what you need? I don't want to hire a generalist to do my patent. And you don't want to hire me to do your patent. I'm not a patent attorney. I do patent licensing, but there's an art to doing patent drafting. So you want to find the right person who, that person or the firm has good substantive experience. There should be a fit. I don't view myself, and some clients like this, some clients don't, but I don't view myself as your attorney that you only call up when you've got a problem or a question. I proactively reach out to my clients and say, hey, I just met this new VC and they're looking for this, and this might be good for you. I feel like I'm part of the team. And for a lot of seed companies and A-round companies, you don't really have in-house counsel. And if you do, it's sort of a junior person who might be doing some commercial work for you. So I want it to be the right fit, personality-wise. I want someone that adds value. I want someone that knows the stuff. And I'm the first person who, if you ask me, Matt, can you do this? Absolutely. Matt, can you do that? Absolutely. Matt, can you do that? Absolutely. After a while, you're going to know, hey, like, there's no way someone could do everything, right? So you have to find someone that, if it's out of their expertise or their firm's expertise, that they're going to tell you, you know what, we could figure it out. But you don't want attorneys figuring out stuff on your nickel. What you want is someone that's done it a million times and that can tell you, we've done it a million times, we will be efficient, here's how it will go, versus a poser who doesn't know what they're doing and figures it out, and everybody loses in that instance. So those are some of the really important considerations. What I have on the slide here are, when you're working with a commercial contracting attorney like myself, it's really important. If you just tell the attorney, okay, I have a SaaS company, I need a SaaS agreement. I know you've got 1 million of them. Yeah, we do have 1 million of them, but you know what? Your business is slightly different. So you want things that are customized. We will recycle and reuse forms to the extent we can, but the more information you give your attorney and the more precise it is and the more granular it is, and the more that your attorney understands your business and you as a person and what you're trying to achieve, and really get down into the nitty gritty, that's how you get better contracts. That's how you get an attorney that is no longer an outsourced mercenary, but someone who is on your team and looking to get you to the next level, so that you don't get on a phone call and say, oh my God, why does our contract say this? I can't believe that we said this and we sent this out. That's not how we do this at all, right? You want to make sure you're on the same page. So that is the last slide. I'm going to answer a couple of questions. Here's my ugly mug and my bio. Feel free to reach out anytime. Here are the last series of questions here. I want to go back. Sorry.
Matt, just so you know, you're 4 minutes over 3:20. So I don't know if you have a 3:30.
I do have a 3:30. I will answer these last two questions. Thank you for
Perfect.
that. I will not prepare for my 3:30. I will have to wait. But so what is the advantage of patents over trade secrets? I'm sorry. Do you think the patent process will be slowed down further in 2021? Yes. Government is actually, downsizing. More patents will slow down the process. What is the advantage of patents over trade secrets? I mentioned that earlier. Patents are for a finite period of time. Trade secrets last forever. It's a little harder to prove a trade secret. If you have a patent and it's valid, you point to the patent and say, hey, you're infringing. And I don't want to make it seem like a patent infringement lawsuit is easy. It's certainly not. It's lengthy, it's expensive. But if I had to litigate something and I was the plaintiff, I would rather litigate a patent dispute rather than a trade secret. So I think it's better to have a patent than a trade secret, unless you need that perpetual recipe for KFC, Coca-Cola, Google's algorithm. Is there any downside to using open source software? I'm going to stop right there. My colleague in a few weeks will be speaking exclusively on open source. I encourage you to attend that. He's fantastic. There are a number of considerations for open source, and he will go through a lot of them. To the extent you're not able to make it, shoot me an email and I'll make sure that I hook you up with him, or we get you the deck. But that is everyone uses open source, but not everyone uses it properly. So it's really critical to do it the right way. And last two questions: as a startup, what should you expect to pay an IP lawyer, for instance, an equity stake, or should you expect a deferred compensation plan or some combination? How can you determine what is fair? There are some law firms that do deferred compensation. There are some law firms that take an equity stake. We do neither. There are certain things that we do where we have what's called a company in a box, where we will form your Delaware C Corp. We will do it for a fixed fee. We will give you all the documents that you need in order to launch, and that's for $3,500. So we have a lot of clients that come in and do that and find tremendous value in that. I would say that since we work with startups so much, we are very efficient in what we do. To the extent we're able to, we will recycle forms. Some law firms will do what's called value billing, and they'll say, hey, it took me, $10,000 to draft this form for somebody else, and all I have to do is switch the names and it's almost identical. They'll bill you $10,000 for that. I would never operate that way. What I would do is I would say, okay, well, we were on the phone for an hour and I had to do an hour of customization. I'm billing you for 2 hours. I'm not billing you for 10,000. So that's a little bit different than other firms. I wouldn't always just look at price. And I'm not saying that because I'm relatively expensive. I say that because if I do something and my rate is double someone else's rate, but I'm going to do it correctly the first time, and I'm going to do it in a quarter of the time because I've done it a million times. You've now saved money by going to the more expensive attorney. So don't only look at their hourly rate, look at the whole package and make sure it's the right fit. And then will you share your slide deck? Without question, I will share that tomorrow. I'm happy for you to reference it. I'm happy for you to reach out to me if you have questions. I am accessible. The only thing I ask is if you're asking me very granular questions and they go beyond, you know, a few minutes here and there, you know, my time is limited too. So I'm always happy to talk to people and see what you need, but at some point it might cross that, you know, freebie threshold. So we'll just have to play that by ear, but by all means, reach out. And I think I have a minute and a half, so I would like to thank you all for your questions, your attention, Rohit and Kara, for the invite and the opportunity to speak to all of you. This has been, you know, fun on my side. I always like meeting new founders and startups and Series A folks. So I hope to speak with you and work with you in the future.
Matt, thank you so much for your time. And as Matt said, we'll follow up, Rohit, Matt and I tomorrow or Thursday with all the information from this webinar. If you did not sign up through our Eventbrite, just drop me your email so I can make sure you're on that follow-up email. But otherwise, thank you so much. And Matt, thanks again for spending an hour and a half with us. We really appreciate it.
If I had another half, I could have spoken another half hour. So thank you all. And thanks again.
Thanks. Bye-bye.
Take care.